Absolutely, without any doubt whatsoever, the union movement took the lead on bringing equality to the workplace for people in the province of Alberta. On every conceivable issue that could arise on a human rights basis in the workplace, the unions were right where you would ideally want an advocate to be. If it wasn't obtained through litigation, it was obtained through collective bargaining. If we think back 20 years, we were really at the forefront of fighting for women's equality in the workplace on every front, fighting against sexual harassment, fighting for equal opportunity, and fighting for women to be treated as permanent features of modern work life. And to that point, really, women had been treated like transients in the workplace, and they would be accorded a position and paid and so on until such time as they got pregnant. And then it was a question, would they be kept on? Would they not be kept on? At the same time, women have the procreative imperative. They bear the burden and the benefits and the blessings of child bearing for the entirety of society. And it seemed only right and fair that there be accommodation for the needs of childbearing. It was a convergence of many different issues for women in the workplace, but perhaps the most important.
When I was pregnant with Rachel and I went down to Human Resources and said, I need to make some arrangements for my coverage to continue while I'm off for the next 6 months. They said, okay, you'll need to prepay $800 and some odd.
At the time in the collective agreement, maternity leave, particularly the health-related portion, was not treated in the same way as sick leave. It was treated as a leave of absence, like if you decided that you wanted to take a year off. If you took that maternity year off, you prepaid your benefits and you were 100% responsible for them. If you were on sick leave, then you were responsible for 25% because the employer paid 75% of the benefits.
I went home and I said to my husband, we have to come up with over $800 in the next few weeks, extra. And he said, why? When I told him, he said, you know, you should really speak to the Human Rights Commission about that because that is sexual discrimination. I said, how do you put that together? At the time, he was doing a constitutional law course, and his professor was talking about the Brooks versus Safeway decision in Manitoba.
Because human rights law is created complaint by complaint, until a particular employer is called to task, there's no legal requirement that he or she abide by the human rights imperatives. So what happened after Brooks was decided was that very little changed except in the Safeway organization and perhaps only in Manitoba. And so it was necessary for someone to bring a complaint forward in Alberta.
I made a phone call to the Human Rights Commission in Calgary and I said, this is the situation and I believe it's pertinent and relevant because of the Brooks versus Safeway decision. And I hung up and within half an hour they called me back and they wanted me to come and start the process.
The human rights complaint was filed and it named not only the employer but also the union as being party to the discrimination because of the clauses in the collective agreement.
It was a huge issue for the hospital because they were named. It was a huge issue for Alberta Hospital Association because they were named, and for the union, they didn't see it as a huge issue. They saw it as a huge opportunity, and they were on board from the get-go.
I initially said, well, the collective agreement doesn't provide for that, but I had recently read the Brooks decision and went, but wait a minute, maybe we can do something here.
United Nurses wanted to get on board and fight for the treatment of women who are unable to work during their period of maternity. So it came to me through the nurses, and of course they very generously said, whatever it takes, we're going to fight this.
The employer's reaction was typical for the time. It isn't in the collective agreement. It doesn't exist. Once they discovered that neither the union, the grievance sue, or the human rights complaint was going to be withdrawn. That wasn't going to happen. They went into full battle mode.
It's like, wait a minute, you chose this. Motherhood is a choice, right? In the inquiry, they tried to go down that road of the risk associated with ensuring this half of the population in a special way. Well, yeah, your choice is that you don't have to recognize women or provide health care for women around pregnancy or provide labor adjustments around, for women. That's a choice, but it doesn't help your society very much.
I was looking for the benefits all the way through maternity leave, because that's part of the whole obligation of society, when it's important to make sure that children in this society have a good groundings.
I am a productive and important part of the workforce, and I have babies, and I can do all of it, and I can do it well. So don't exclude me from your benefits packages because I have a vagina. You can't separate women from the workforce like that. And maybe years ago you could, but it's important to understand that when we fight for equality, equality doesn't mean that I'm going to treat you the same way as you. You're a woman and you're a man, I'm going to treat you exactly the same way. That's not equality. Women have a special, a unique metabolic function that needs to be taken into consideration when we are part of the workforce.
What equality is about is freedom, and what freedom is about is absence of restraint. And when we have artificial barriers at the workplace to full participation, we don't have freedom. With counsel for the Commission and counsel for the Alberta Hospital Association, we could all see this as an emerging issue and an important issue. There was just consensus amongst us that we should put all of the important issues to the tribunal, even though the complaint perhaps was narrowly laid. Because if it wasn't going to be this case, it was going to be other cases.
I felt absolutely disempowered in the process of the inquiry because it's so impersonal, right? It's about you, but they're talking about you like you're just a piece of meat, a number and a piece of meat. It was odd to say the least, because they would be up there, the opposite side, putting forward all the reasons why this would be too big a burden. The theory for insurance is that people will take more than they need. People are greedy, and in this case, women are greedy, I guess. The only redeeming quality was the doctor from the World Health Organization, the epidemiologist, who took the stand to explain how things really were.
He came and he described the fundamental and profound effects on a woman's body of carrying a child to term and giving birth. And it was really quite an eye-opening experience, I think, to particularly the women in the room, that we would have ever been required to simply soldier on without any broader support from our workplace or from our employer.
And that was, for me, was just very reassuring. But that was late in the day. That was late in the inquiry. It was a stressful time for me. I'm glad I did it. When you're trying to change a system, the idea of what's right and wrong is what drives you. Yeah. It feels awkward when something is about you and it's that controversial. I was raised in a very, very traditional community setting. When this happened, there was a little bit of an outcry. It was like, what is she doing? She's costing us more money. Is she really taking our government to court? They came around to understand that they couldn't control Susan. She was just she seemed to, like, I was passionate about certain things and I believed in certain things and lots of this stuff is about women's rights and women's issues. I didn't have a huge amount of that emotional support in my environment. I had my husband, but not a lot of other people were going, good for you, Susan, right? I think I got a letter from one lady down east who was a stranger, a complete stranger. She sent me a card and said, thank you so much for doing this. Yeah, amazing. And she sent me a magazine, and there was a character of me pregnant on the cover of it. And so there are strangers in this world that are as passionate as I was about it. And I think that that's how we change as a society, how we evolve.
The complaint was largely successful for Susan Parcels. It established the concept that health-related absences from work as a result of pregnancy were to be treated as valid health-related reasons for the purposes of insurance, so that women would be paid throughout the usual period of what used to be called confinement, 6 weeks prior to delivery, 6 weeks after delivery.
I went through a whole range of emotions about it. It did take a lot of courage, because there was a lot of times I was hiding in front of the TV or covering my ears when the editorials were going on the radio, or I knew I was part of it, but it was like, oh, here we go, I'm going to be sick. I think that nobody wanted to make the decision, right? That was what it was. Nobody wants to set the precedent. So Alberta Hospital Association, oh, no, we can't do this. We want to set this precedent. So we're going to appeal it. And then the Court of Appeal will be responsible for saying yes or no. And then, so that it's never in the hands of anything other than the justice system.
When it went to appeal, the employers were taking issue with the entire sort of decision, the decision of whether or not this was indeed discrimination. They were unsuccessful in changing the decision to any material extent.
After the decisions came out initially, there was a letter of understanding that provided for what the benefits were for the health-related portion of maternity leave. Eventually, that letter of understanding became part of the main body of the collective agreement. That was kind of an exciting time. Again, because it was so new, and we had to figure out how to get, our job was to maximize the benefit that we'd fought to get.
And I think everybody felt good about it. I think in the end, even some parts of the employers' organization felt good about it, because if women cannot go into the workplace and reconcile what they want to do, which is be mothers, with what they also want to do, which is have careers, then it is an eternally frustrating problem.
It was a very long process. I believe that Susan's child was in grade 1 or 2 before it was actually implemented.
I wanted that badly to win. I did. And I wanted to win for women in the workforce. My story was one of hundreds of thousands of stories, because this wasn't just happening in Red Deer, Alberta. This was happening all across our nation.
It really did become a guiding light. And when other employers would be recalcitrant about implementing what were by then their obligations under the human rights legislation, we could use that decision.
That opportunity of the Human Rights Commission experience has actually given me enough courage and self-confidence to go further, to do domestic violence treatment programming, to work in my community to make it a safer place for women and children. It's a part of who I am, and I'm not afraid of it anymore. I will speak out about these issues. I don't care if people disagree with me.
As it happened, several of us in those proceedings were pregnant. I was pregnant, my daughter's 20, so I'll never forget that Parcels case for many reasons, but that's one of them.
And yes, she's proud to be that baby, and she is very pro-feminist. She is definitely her parents' child.